Good afternoon, everyone, and welcome to our disrepair presentation. We'll wait for a couple of minutes just so that there can be a few more joiners, and then we'll start. Sorry about my flushed face. I promise I haven't been on the booze. It's that our heating has broken, so we've got fan heaters everywhere, and it's the hottest place in the world here at the moment. Okay, so it seems like we've got a good amount of joiners now, so we'll start if that's okay. So good afternoon, everyone, and welcome to our housing snapshot. This one is about disrepair. So my name's Simon. I'm a partner in the housing management team, and I'm joined today by my colleague Joe. Do you want to say hello, Joe?
Hello.
So Joe is an associate in the housing management team as well. Um, so um, we're gonna talk about disrepair. There's a summary slide, isn't there, Joe? Can we move to that, please? So we're going to talk about kind of landlords' repairing responsibilities. We're going to talk about fitness for habitation, the standard of repair, uh, what's outside the remit of landlords' responsibilities, how to deal with complaints, what are the timescales, access, uh, give you practical hints and tips about records, and then talk about proceedings and the fixed costs regime and how you kind of can keep your spending to a minimum if you can, and that sort of thing. So hopefully a whistle-tops kind of guide to disrepair claims. I apologise in advance that it's quite lawry, but I don't think it's possible to talk about this subject without being lawry, and obviously we're lawyers, so I apologise. Not many jokes, but we'll do our best. So let's start at looking at what are the landlord's repairing responsibilities. So the landlord's responsibility in relation to repair, in relation to disrepair, comes from both implied and express obligations. The first port of call when looking at what a landlord's repairing responsibilities are will be the lease agreement. So in the agreement, you would expect to find information about what the landlord and the tenant are responsible for and the standard of repair that it is expected. With social housing, there may be some additional express responsibilities in the lease. Sometimes, for example, some housing associations, even when the tenants actually own outright the freehold properties, they take on repairing responsibilities. So always look at the document. But no matter what the document says, there are some implied obligations too. Obligations are implied into every tenancy agreement by statute. Section 11 of the Landlord and Tenant Act 1985 implies an obligation on the landlord to keep in repair the structure and exterior of the property and to keep in repair and proper working order the installations for the supply of water, gas, electricity, sanitation, space heating, and heating water. The obligation to keep in repair is a continuing obligation on the landlord to keep up the standard of repair throughout the tenancy and to put the premises into repair if they were not in repair at the start of the tenancy. Structure and exterior of the property has been taken to include the walls, windows, roof, the access steps, and any paths to the property, and in some cases, the internal wall plaster. Gutters, drains, and external pipes are expressly included. As a landlord, you cannot opt out of those obligations, and where there is a conflict between the tenancy agreement and statute, the statutory obligations will prevail. Statute indicates the minimum level of responsibility, and the lease agreement may add enhanced but not diminished responsibilities. The landlord must carry out repairs at their own cost, and the landlord is not permitted to charge the tenant for costs of repairs or to recover those costs through the service charge. The obligations apply whether or not the rent is in arrears, and as noted on the slide, you can't at all kind of criticize a tenant for not paying in relation to disrepair. You just have to take that on the chin. Okay, Joe's going to talk now about fitness for habitation.
So on the back of those statutory responsibilities, in 2018, the Homes Fitness for Human Habitation Act was introduced. And this amended the Landlord and Tenant Act to create a new implied obligation in all tenancies that a property must be fit for human habitation at the beginning of and throughout the tenancy. Fit for human habitation means that it is safe, healthy, and free from things that could cause you or anyone else in your household serious harm. And that test also applies to any parts of a building, such as shared hallways in an apartment block. So it applies to the common parts as well. The test of whether something is unfit, we go back to the Landlord and Tenant Act 1985 in section 10. And there are 10 factors which the court would have regard to when assessing the fitness of a property. These factors are repair, which in the general traditional section 11 repair issues, which Simon's talked about, the stability of the property, whether the property is free from damp, the internal arrangement of the property, what natural lighting is available, is the ventilation appropriate, which involves asking questions like, can those windows be opened? Do there need to be fans installed? It applies to the water supply and any drainage and sanitary conveniences and how you get rid of wastewater. And it also considers what facilities are available for preparation and cooking of food. Once you've gone through those, then for properties that are based in England, we also have to look at the prescribed hazards. And there are 29 listed prescribed hazards in the Housing Health and Safety Regulations 2005. And these provide a rating system for assessing hazards and identifying the best way of dealing with them. And the list of hazards includes things like damp and mold and excess cold. Once you've gone through those hazards, you're back to section 10 of the Landlord and Tenant Act 1985, which caveats the test for fitness by stating that a property is only unfit if and only if the property is so far defective in one or more of those that it is not reasonably suitable for occupation in that condition. So the tenant has a really high hurdle to get over. They need to establish that one or more of those conditions exist and that property is so bad it's not suitable for them to live in that condition. And you can contrast that with the previous test, which was that the property should be in all respects reasonably fit. So the higher threshold for the tenant is balanced by the fact that the judge will consider what is reasonable subjectively on a case-by-case basis. So if you have a tenant with no health conditions, the property may not, and the property might be fine, it might not be fit for a tenant who has a disability like a respiratory condition or severe asthma. And if a landlord is made aware of a tenant's health condition, then the landlord needs to pay special attention to how the condition of the home may be affected for habitation by that particular tenant. And Simon's going to talk to you about the standard of repair.
Thanks, Joe. So the standard of repair expected will also be assessed on a case-by-case basis. Consideration is to be given to the character, age, and prospective life of the premises. However, it's emphasised that this does not justify leaving a tenant in a situation of material discomfort, even when the prospective life of the premises may be short. There's also an obligation to make good any damaged decorations and to decorate after completing any repair work. The landlord's standard of repair does not apply to items which the tenant is entitled to remove at the end of the tenancy or to defects caused by a tenant's default. Joe's going to talk now about the pre-action protocol for housing condition cases.
Yeah, so if your tenant wishes to make a claim for disrepair, Then the way that the claim should be handled is governed by the Pre-Action Protocol for Housing Condition Cases, which came into force in January 2020. It applies to residential property based in England only, and it relates to claims by tenants and others in respect of poor housing conditions. And the protocol describes the conduct that the court will expect prospective parties in a housing condition claim to have engaged in prior to the start of proceedings. The protocol is intended to encourage the exchange of information between the parties, landlord and tenant, at an early stage, and to provide a clear framework within which parties in housing conditions claim can attempt to achieve an early and appropriate resolution of the issue. The court has the power to order parties who failed to comply with this unreasonably to pay additional costs or to be subject to other sanctions. So before you get to commencing the protocol, landlords should be aware of any poor housing conditions in their stock and be given the opportunity to resolve them. And the protocol is intended to be used where your own internal dispute resolution procedures have been exhausted, rather than a means of the tenant bringing issues to your attention in the first place. It's important to reiterate that when a landlord receives correspondence from a tenant initiating the protocol, that the landlord doesn't then engage from their own internal complaints procedure or the repair issue itself. So commencing the protocol does not constitute the tenant taking legal proceedings. And many of you will be aware of the 2-year-old child, Awa Bishak, who tragically died in 2020 from a respiratory condition caused by extensive mold in his 1-bedroom Rochdale flat. And following his tragic death, the then Housing Secretary Michael Gove warned landlords that they must not hide behind legal process when responding to damp and mold complaints. The courts don't look favourably on landlords where repair works have been halted during the pre-action protocol. Instead, the best course of action once a landlord becomes aware of the initiation of the protocol is to inspect the property and complete repairs as soon as practicable. The onus isn't completely on landlords. We've put on the slide the case of Atkins and Bristol City Council, which demonstrates the importance of using the complaints procedure prior to starting the protocol. A tenant applied to court for disclosure and had their application refused because the council's internal complaints procedure had not been exhausted. The protocol really reiterates that alternative dispute resolution can be and is encouraged to be pursued at any stage. So parties need to be looking to resolve disputes. And the Court of Appeal in a case called Churchill and Merthyr Tydfil CBC confirmed that courts have the power to order a stay of proceedings for parties to take part in non-court dispute resolution, so to try and sort it out between themselves, such as an internal complaints process. And in making that order, the courts will just need to make sure that the order doesn't impair the claimant's right to a judicial hearing and that any dispute resolution procedure is proportionate to settling the dispute fairly, quickly, and at a reasonable cost. The vestige is very much that you should be trying to resolve the matter without the need for court, not pausing your investigations because the tenant has made a complaint or a claim.
Thanks, Joe. Hopefully it wasn't too triggering to see Michael Gove's name on the slide for that long. So looking now, what's outside the remit of landlord's responsibilities? The landlord is not responsible for carrying out any works or repairs that are needed due to the tenant not using the property in a tenant-like manner. So this would include things like the tenant not using the heating or failing to ventilate the property properly. It might also include things like the tenant causing damp and mold by drying clothes inside or by having cluttered rooms or significantly by hoarding. Any breaches of covenant will also provide the landlord with a defence. For example, if the tenant is on the one hand saying that the property is unfit, but on the other denying access to the property for the landlord to remedy the unfitness. The landlord's not responsible for rebuilding or reinstating the property if it's damaged or destroyed by fire, tempest, flood, or other inevitable accident. Finally, the landlord does not need to keep in repair or maintain anything that the tenant is entitled to remove at the end of the tenancy, such as kitchen appliances, unless, of course, it's in the lease agreement that the landlord is responsible for those items.
Okay. So dealing with complaints, we touched on the pre-action protocol, and obviously the message there is your complaints process is one of the most important parts of dealing with this. Um, I'm sure lots of you will be aware of the Housing Ombudsman's October 2021 report, Spotlight on Damp and Mould. If you're not in that report, there are several recommendations made to landlords who are dealing with tenant complaints. And the Ombudsman also issued a follow-up report in February 2023, which are both worth a look. So your complaints process needs to be running alongside any pre-action correspondence in relation to a claim. We've covered it's not a landlord's responsibility to repair issues where they're caused by a tenant failure to occupy the property in a tenant-like manner. However, the Ombudsman's recommendations are very much that the landlord should take responsibility rather than simply looking to infer blame on the tenant. So the Ombudsman's recommended that a landlord should carry out a thorough investigation, and until there is good evidence to suggest that it's a tenant-caused issue, the landlord shouldn't jump to that conclusion. And any actions that place the onus solely on the tenant should be avoided. The Ombudsman made the point that your complaint system should be there so people can raise their issues and get them addressed quickly. This will help you avoid claims. And having lots of complaints is not necessarily a bad thing. It shows you that your complaint system works and that you have a process for tenants being able to get in touch with you and to report their concerns. When you are communicating with a tenant, remember that ultimately what you say may end up in front of a judge. The Ombudsman made recommendations for dealing with communication, such as avoiding language which leaves tenants feeling blamed, making sure you know your tenants and know which ones aren't contacting you. And that can help you identify who might need more support or areas where your system might need improving. When you make appointments for surveys and repair works, make sure you give your notice that is set out in the tenancy agreement. And you're also, as landlords, encouraged to be flexible around the tenant's commitments, such as their working hours. And although it's important to deal with issues as soon as possible, if you turn up unannounced, you often have a wasted visit, and it doesn't help you build a good case if a claim was to be brought in court. You can use other methods of communication, such as text and email, but if the tenancy agreement specifies that the notice should be in writing, all appointments should be confirmed in that way as well. And unless your tenancy agreement provides for it, writing doesn't automatically include emails or texts. In order to manage the tenant's expectations, keep in touch with them throughout the process. Even if you don't have good news, good communication will help reduce the tenant's frustration and will be looked at favourably by a judge. And then there's a note on the slide about timescales. At present, the landlord has a duty to repair any problems in a reasonable amount of time. What a reasonable amount of time is not defined anywhere in the statute, and it will depend on what the problem is and how serious it is. It will be down to the judge to make a decision about a reasonable time, considering factors such as how extensive the works are, the availability of materials, and the cost of the works. The question can be quite difficult to argue and defend in court, and therefore the best way to defend claims or avoid them altogether is by dealing with the issues as quickly as possible. Social housing landlords can be held accountable by the Housing Ombudsman for the length of time it takes to fix problems within a home. And what's next? We mentioned earlier the tragic death of Ayowa Baishak, caused by the damp and mould in his home. And that tragedy led to amendments to the Social Housing Regulation Act, which became law in 2023. The Act proposes to introduce strict time limits for social landlords to address hazards and empowers social housing tenants to request information from their landlords, promote transparency and promote accountability. It also introduces stronger regulator enforcement powers, as well as requiring social housing managers to possess specific qualifications or be actively working towards them. And the timescales will be introduced by regulations. Previous government consulted in early 24 on what those regulations would look like, and prior to the election was considering the responses. We know that the current government has also proposed to bring in those timescales. We're still waiting for the regulations to come into force, but the kind of proposals on the table, a landlord should investigate the hazard within 14 days of being made aware that there's a potential hazard of the property. The investigation has to be sufficient to find out whether there is a hazard. You might not actually have to go to the property, but whoever's looking at it must have the right skills and experience to do so. The landlord should provide a written summary of findings to the tenant within 14 days of being made aware of a hazard. The summary must include details of any hazard identified and next steps, including an anticipated timeline for repair and a schedule of works. The current proposal suggests that the investigation and that report need to be completed within the first 14 days. If you identify a hazard, works must begin within 7 days of the written summary being issued. And the previous government proposed that beginning repair works would entail a worker being physically on site to repair and rectify. Again, we have works being completed within a reasonable period of time. And the previous government indicated that fixing a time period for works might result in quick fixes that might not fully resolve the matter. So we may still see that word reasonable moving forward with any new rules that we get. Landlords must action emergency repairs as soon as practicable and in any event within 24 hours. And the proposal is something that requires emergency repairs as something that present a significant or imminent risk of harm, and that what this looks at is the situation on the ground. The previous government's consultation paper gave the example that a broken front door where a house faces a busy road and a child lives there would need a faster response than a broken door in a block of flats occupied by 2 adults. If the investigation finds a hazard that poses a significant or imminent risk of harm or danger, which can't be made safe within the specified timescales, the landlord must offer temporary accommodation until the property is made safe, and that is being phrased as decanting the property. There's a proposal that the landlord has to keep clear records of all attempts to comply with the requirements, and there were also some examples set out in that previous consultation paper of what would constitute reasonable attempts for access. Things like making 3 attempts to contact the resident, working with residents and offering time slots for them to choose from, which take into account their needs. If you can't get there within that time slot, then or you can't access within a time slot, leave a notice saying that an attempt was made and provide some contact details and then contact the tenant to arrange an alternative time. And the proposal was that you would not be expected to make more than 3 attempts to access the property within the agreed slot, but you'll need to keep evidence of all the correspondence. So we're still expecting to see some sort of secondary legislation giving effect to all of these timescales, whether or not they're exactly those or there's some new ones. And we know that in the private rented sector, the Renters' Rights Bill is currently in its 2nd reading in the House of Lords. And that proposes to extend these kind of requirements to the private rented sector. So private landlords will also need to be swiftly acquainted with the new requirements and ensure that they have a contractual infrastructure in place to achieve compliance. If you have well-running inspection procedures in place now, that could ease your transition for dealing with matters well within the timescales when they come into force. So I'll pass you to Simon about the kind of steps that you could take.
Thanks, Joe. So looking at access, I mean, it sounds obvious, but the landlord must be given access to the premises, and that's set out in paragraph 7.6 of the protocol, which says tenants must allow the landlord reasonable access for inspection and repair in accordance with the tenancy agreement. The landlord should be given reasonable notice of the need for access. Sorry, the landlord should give reasonable notice of the need for access, except in the case of emergency. And those kind of provisions are usually replicated in a tenancy agreement. So we would usually expect to see a clause in a tenancy agreement that allows the landlord to inspect on giving 24 or 48 hours written notice, save in emergencies. Section 11 of the Landlord and Tenant Act 1985 implies a term in a contract that permits the landlord to access the property to inspect its condition and state of repair. Access requests should be made in writing and give at least 24 hours notice. And there's a similar provision in section 16 of the Housing Act. If your tenant will not let you in, but you're worried about disrepair or there's a complaint of disrepair, then you need to maybe think about getting an injunction. And the general consensus is that a landlord should make 3 genuine attempts to gain access to the property before seeking a court injunction. And that those 3 attempts would usually be enough for a judge to make a ruling in the landlord's favour. Don't forget you need to document those 3 requests in writing, and you need to show that you've brought those requests to the attention of the tenant. So, using special delivery post, hand delivering and taking a photo of the envelope going through the tenant's address, premises. If the tenant wants contact by email, putting a read receipt on it, those kind of things. Mental health issues often come into play here, and in cases of OCD and psychosis, you should involve social services if you can before taking a more heavy-handed approach. Um, there's a balancing act where there are high risks. For example, if you can't complete a gas and safety report due to the tenant's hoarding, which has created a fire hazard. In cases such as these, reports from specialists such as the fire service would help strengthen a case for an application for an injunction. But make sure, if you are going down the injunction route, that you have your Equality Act assessment on your file before you commence the injunction proceedings. Moving on to records now, it's important that a landlord has a means of recording and maintaining all communication with tenants. You should keep detailed records of works done to the property and records of any complaints made. This includes communication that's unrelated to disrepair. For example, if there's evidence that a tenant has been communicating with a landlord regarding other issues relating to neighbour disputes without mention of the repair issues, this could be evidentially useful in defending a disrepair claim. Images of the works completed are also key. Keep in mind, and this is really important for your subcontractors, that when working on any record, it could one day be used as evidence in court. So your words should be as detailed as possible without going over the top. A judge will generally find good records compelling, and it will be easier to defend a case if you've got good records. Subcontractors are often working against strict time pressures and have a high workload. These conditions can often see the deterioration of the quality of the note taking. So I think that you should offer training to your subbies to ensure that they know the law and they know the importance of keeping good records throughout. For example, if your subcontractors are doing, say, gas safety checks at the property, and they go for a wee and they see that there's some damp and mold in the bathroom, they should take a picture of that damp and mold, but they should take a picture with something that would accurately show the size of the area of damp and mold. So, if they haven't got a ruler with them, they could hold their finger up against the area of damp and mold so that a scale could be seen between the area and their hand. Because sometimes those images, if they're not subject to any kind of scaling, can show what looks like a much more serious issue than it actually is. If your subcontractor though goes into a bathroom and it's absolutely swamped in black mold and it's everywhere from floor to ceiling, I suggest that they don't take a record of that, but just immediately get out of the property and escalate it immediately so that you go in and do the repairs as swiftly as you can. Okay, that's all for me. I'm going to hand you over to Joe on legal proceedings now.
Yep, I'm just spotted the time, so we must have spoken a lot slower than normal today. But I will take you through this if you have time. Legal proceedings. Once your complaints procedure and the pre-action protocol has run its course, if the dispute has not been settled, then the claimant may take the natural next step, which is to issue court proceedings. And in a case for disrepair, there are 4 points on which the tenant must persuade the court Firstly, they have to show that there's an actionable defect. So we go back to those Section 11 tests, the unfitness and the prescribed hazards defects that we discussed earlier. Secondly, the landlord must be on notice of the issues. So they just have to be aware of it. And that notice can be actual or constructive. Actual notice is where the landlord has been informed of the issues. So the tenant has used the online complaints procedure, or they've made a telephone call, or an email has been sent. And constructive notice is where a landlord knew or ought reasonably to have known of a repair issue. So that contractor visiting the bathroom that Simon's just discussed. If there's been an inspection of the property since an internal problem first showed an issue, provided it was discoverable by the naked eye, the landlord can be considered to have constructive notice. If you visit a property for any other reason and see something that may need repairing, you are on notice of the issue. Notice or knowledge need not be technical and it can be imputed. That's a lovely legal word. But if issues are brought to the attention of the landlord's workforce or any other employees, if they are acting on the landlord's express or implied authority to receive complaints of disrepair, again, that's your contractor. Information received by the landlord must be sufficient to put a reasonable person on inquiry about whether works of repair are needed. There must have been a failure to repair within a reasonable time, and obviously this might change with the timescales coming in. But a property being in disrepair is not in itself enough to establish a claim. There must have been a failure to repair within a reasonable time. And finally, there must be a loss. So the tenant has to show an actual loss as a result of the issues, something that they have suffered as a result. And that takes us on how we would calculate damages for the tenant. If the tenant can show that the disrepair has sufficient impact on their enjoyment of the property, and they can prove those 4 points, so there's a defect, that the landlord's on notice, the landlord's failed to repair it, and the tenant has suffered a loss, that the tenant will be entitled to damages or compensation. And the rent of the property is used as the basis for that calculation. A percentage of the rent that was paid while the tenant lived in the property with disrepair is how it will be decided. And the actual percentage that will be awarded depends on the severity of the disrepair. If the property is completely uninhabitable, the tenant's going to get 100% compensation, but this is really rare. So normally you're looking at compensation between 25 to 50% of the rent of the property. And then the tenant's entitled to their special damages. So these are monetary losses which have been incurred directly because of the disrepair. And that can include things like spoiled decorations, damaged furniture, loss of earnings due to being away from work, increased utility bills if they've been running dehumidifiers to try and dry out the property. The tenant's claim will be subject to the Limitation Act, so the tenant will only be able to claim damage for the past 6 years. Any damage that predates that will be time barred. And we've just put a note on there about the fixed cost regime. The general position is that the loser pays the winner's costs. So tenant is entitled to recover damages. They will also be entitled to recover their legal costs. And over the last few years, fixed costs have been introduced in civil litigation cases, which means that the sum recoverable from the loser is subject to a prescribed sum, which is often substantially lower than the amount that the winners actually spent on their legal representation. At the moment, fixed costs recoverable costs in the fast track, which is where the tenant's compensation is less than £25,000, don't apply to housing disrepair cases. And a previous suggestion was that we wouldn't see fixed costs in housing disrepair cases for 2 years. That suggestion was back in February 2023, so fixed costs may well be back on the table soon. But the importance of fixed costs is that without them, costs in housing disrepair cases are at large. And it means that as landlords, you need to take a commercial approach to settlement. In most claims, the costs far exceed the cost of repairs and the damages combined. And sometimes legal costs can be quite extravagant, and that can have a direct impact on the services that registered providers can actually give to their customers. And that money would be better spent reinvested into the communities that they serve. So this all comes back to the start. If you feel your tenant has a valid claim or complaint, the advice is always to try and reach early settlement to avoid unnecessary litigation. And that, of course, needs to be balanced with the risk that if you pay out to shut matters down, then word can easily spread amongst your tenants, and you can find yourself inundated with claims from tenants who like the idea of some, in inverted commas, free cash. Defending a claim can also be costly. So in addition to the tenant's costs, you've got your own legal costs, and there's little prospect of recovering costs from tenants, even if you're successful. Litigation always has its own uncertainties. Even if your case is very robust and very strong, the case can still fall at the final hurdle. And so you have to have a lot of faith in your repairs process and be content that your records are in order if you want to pursue a defence all the way to trial. If there's any uncertainty, then adopting a commercial approach and seeking an early settlement could be the better option. And at the very least, making offers to settle can give you some cost protection if the tenants refuse to engage or if the tenants have unrealistic expectations about the value of their claim. And every case just has to be assessed on its individual merits and facts. Thank you.
Thank you very much, Jo. So to conclude, I think the message that we wanted to get over is that the disrepair protocol contains strict timelines, and you do need to make sure that you comply with them, but it's something that you can probably do quite happily yourselves without instructing lawyers for all but the most serious cases, because we can help you to do this work yourself so that you're not kind of spending your grant funding money on disrepair claims disproportionately. If we deal with it, or if another firm of solicitors deal with it, as Joe's just kind of highlighted in the last slide, our costs can easily outweigh the claim itself and the damages. The cost of the works and the damages. So you need to deal with these things proportionately, and that is setting up a streamlined system to deal with it yourself. But if you get a kind of a hideous claim, which I think is hopefully unlikely for the housing associations that we work for, you go out and you do your repairs, but if you've missed one and the property is a true disgrace, then that's where you should be spending your legal pound. But even then, you should be getting the works done immediately to reduce your damages. Thank you very much for listening. Thank you, Jo, for presenting with me. Sorry that we have gone over by 8 minutes. Have a good rest of the day. Thank you. Bye-bye.
Thank you.